Hello, my name is Hamid Abdul Karim, and I am counsel at the London office of Three Crowns. I'm qualified to practice law in Nigeria, and over the past decade, I've had the privilege of being involved in several topical arbitrations in Nigeria and related litigation. Over the course of the next few minutes, I will discuss a recent development in the jurisprudence concerning the power of Nigerian courts to issue anti-arbitration injunctions. It was the 4th of October 2012. I remember being at the Lagos office of a client making final preparations for a 7-day hearing in an arbitration that was scheduled to commence in a fortnight. The dispute involved a $1 billion claim arising under a deep offshore production sharing contract. And then we received an email from opposing counsel. It turned out they had sought and obtained from the Federal High Court of Nigeria an injunction restraining the parties and the tribunal from taking further steps in the arbitration. For anyone who has been involved in Nigeria-related arbitrations, this will be a familiar story. You are always alive to the risk that your opponent, if he thinks that there might be some advantage in doing so, will approach the courts and ask for an anti-arbitration injunction on the basis of some excuse or the other, and usually he will succeed. We would fight the injunction in this case vigorously over a 9-month period, culminating in a seminal decision of the Court of Appeal delivered on the 12th of July 2013, overturning the injunction in that case and holding that the courts had lacked jurisdiction to make it. The ratio of the decision was simple. The Court of Appeal relied on Section 34 of the Nigerian Arbitration and Conciliation Act, which adopts Article 5 of the UNCITRAL Model Law, and states, and I quote, "A court shall not intervene in any matter governed by this act, except where so provided in this act," close quotes. In the court's reasoning, since the arbitration legislation did not specifically empower the courts to issue anti-arbitration injunctions, the courts could simply not make such orders. That decision is Statoil and NNPC. Statoil was a breath of fresh air. From my practice alone, I recall at least 3 cases in which the decision in Statoil was the reason why various lower courts declined applications to stop arbitrations in which I was involved. And then in 2015, the Court of Appeal muddied the waters. The court did not overturn Statoil, but in Cresta and SPDC, the Court of Appeal distinguished Statoil, holding that the principle established in that case applied only to domestic and not foreign arbitration. And so in Cresta itself, the court went ahead to issue an anti-arbitration injunction in respect of an ICC arbitration seated in London. As you would imagine, the decision in Cresta created significant problems. It provided cover for dilatory arbitrants to at the very least apply to the court for anti-arbitration injunctions and see what would happen. Thankfully, there is good news on that front. In a decision handed down by the Nigerian Court of Appeal on the 17th of February 2022, EcoBank and others, and ITO Eastern and others, the Court of Appeal has returned to its position in Statoil. In EcoBank, an oil company sought from the Court of Appeal, amongst other relief, an injunction restraining a consortium of financial institutions who were its lenders from continuing to prosecute a London-seated ICC arbitration that they had commenced against the company. The Court of Appeal rejected the application, holding that, firstly, because the parties had agreed to ICC arbitration seated in London in the facility agreements governing their relationship, an anti-arbitration injunction preventing the financial institutions from prosecuting the arbitration they had commenced would essentially amount to rewriting the parties' commercial bargain, something the court had no power to do. Secondly, and interestingly, the court held that being a court established for the Federation of Nigeria, it would be acting beyond the territorial scope of its authority if it purported to restrain the financial institutions from prosecuting proceedings they had commenced outside Nigeria. The latter part of the Court of Appeal's decision will no doubt be fodder for many academic articles and panel debates in the months to come. But at least it is clear that unless the Court of Appeal again reverses course, or the Nigerian Supreme Court takes a different line in the future, arbitrants should enjoy some safety from previously rampant anti-arbitration injunctions issued by the Nigerian courts. For now, thank you for listening.
arbitration. Courts and arbitral tribunals generally have concurrent jurisdiction to decide applications for interim measures in aid of arbitration. And parties and their counsel must make strategic decisions about which forum to go to seek initial interim relief. And in this program, we are going to do 2 mock hearings in connection with applications for interim relief in a hypothetical international arbitration seated here in New York. First, we'll have a team of advocates that I'll introduce in a minute who will be seeking a TRO before a United States District Court judge. And then we'll switch, and we will have another set of advocates seeking relief before an interim arbitrator or before an emergency arbitrator. And at the end, we'll have a discussion examining the consequences of the choices made and the issues that should be considered by the parties and their counsel in making this decision. So there were the hypothetical we're using, the facts were in your CLE materials, but Martin had a big role in putting those together and is just going to talk us through them quickly so we're all on the same page when we start.
Yeah, you also all have the mock fact pattern in front of you. And as you see there, and the title of this program is Choosing Wisely, the Challenge of Interim Measures in International Arbitration. And as emergency arbitration becomes more mainstream and more used than it was in the past, the decision with respect to whether to choose to go to a federal court or a state court, or whether to seek a emergency relief in front of an arbitration panel becomes an extremely important decision for advocates in relation to their advice and counseling of their clients, but also to those that serve as arbitrators in the forum and their ability to apply different standards. And one thing that will become clear as we go through the mock fact pattern, both from a court perspective, but also an emergency arbitration perspective, is how the different standards that might apply in federal court or state court versus in an international arbitration and an emergency arbitration, how those impact and have an impact on the outcome and also on the advice that might be given to a client. And we've chosen a mock fact pattern that is based upon a recent Third Circuit decision that came out in August of 2022, which reversed the decision of the district court in relation to the preliminary injunctive relief that was sought in that case. But we've set it in the period of early 2020, in which time we were entering into the pandemic. And I'm just going to briefly introduce sort of the general facts so that everyone has a sense of what's going to be argued in front of both the judge and the emergency arbitrator, so everyone's sort of aligned. But the case takes place again in early 2020. There was a company, SV Health, that's a New York corporation that was a distributor of healthcare products in the US. Manufacturing Best was a Malaysian company, and it manufactured PPE, personal protective equipment, things such as N95 masks and other equipment that was used for healthcare business. MB didn't really have a presence outside of Malaysia in early 2000, and it began its relationship with SV Health in 2003. The parties started a distribution relationship. That continued for some time, and the parties decided to enter into a new distribution agreement in 2017. That new distribution agreement provided for the requirements of SV Health to use its best efforts to promote the products of MB and to use its best efforts to really advertise and achieve sales through its distribution networks. The contract at issue provided for termination upon a 60 days written notice of a material breach that was not cured. And it included an arbitration provision, which required disputes to be settled under the New York administered arbitration rules, and provided for emergency arbitration in which emergency relief could be granted on interim and conservatory measures could be granted based upon the demonstration of necessity. As we'll see in our subsequent discussion, the choice that parties have in selecting the arbitral rules that apply and potentially emergency measures or emergency relief provisions is important. The rules that we've selected here for the mock fact pattern are fictitious, and they're not rules, but parties would seek to apply either an arbitral institution or specific rules that would apply. Consistent with the concurrent jurisdiction that federal courts have with arbitral institutions, the provision provided that going to a court to seek interim relief would not constitute a waiver of the right to arbitration under the contract. The distribution agreement was governed by New York law, and the parties throughout their relationship had a significant amount of success. Sales grew under SV Health's promotion and distribution until 2018, sales began to falter. Prior to 2018 up through 2017, there had been double-digit sales growth year after year. In 2018, the sales began to flatten, and then in 2019, they declined. As a result of the decline, MB sent a notice of material breach on January 10th of 2020. The parties were unable to reach an agreement with respect to that notice of material breach, and MB sent a notice of termination on March 16th, 2020, with an effective date of April 15th, 2020. In the interim period, on March 25th, MB had already verbally agreed to enter into a distribution agreement with another healthcare supplier, but did not have a written contract. KSY was the name of that company, and it was started by one of the 50% owners of SV Health that had departed the company previously. SV Health started an arbitration seeking interim in emergency measures, as well as ultimate relief on April 3rd, 2020. And as you'll see in the two fact patterns, we'll have one in which they sought the emergency relief in a federal court, and the other scenario in which they chose to seek the emergency relief and interim measures within the arbitration itself. The hearing is set for just 2 days before the termination becomes effective and prior to reaching a written agreement with KSY on April 13th, Monday, April 13th, 2020, as we were continuing to head into the pandemic. And with that, we'll introduce the first set of panelists that are presenting the mock as if it were in federal court. And Lee will introduce our panelists and we will proceed.
And so the participants' biographies are available on the New York Arbitration Week website, and I'm not going to recount their many accomplishments or it would take all their time. But for our first mock, we are lucky to have with us Catherine Forrest, who is now a partner at Cravath, Swaine & Moore, but who previously served 7 years as a district court judge in the Southern District of New York. So we have the real thing. And then as advocates, for the plaintiff, we have Carrie. Oh, sorry. I got it. Thanks. Got it. Thanks. We have Carrie Ann Law of Kramer Levin, and we have Andrew Finn of Sullivan and Cromwell. And so I would ask them to take their places. And go ahead. As you're doing that, one thing I would note, the first sort of difference between the emergency arbitration and the court is, if you were in a court hearing, it would be public. Your papers would very likely be public. It's very difficult in the Southern District to get things filed under seal. I think you'll see the preparation of the decision maker may be different, the types of orders that they'll issue, and the types of evidence that will be presented. So Judge Forrest, we'll let you take it away.
Hi, all right, counsel. I've just been handed a set of papers that indicate that you've got an application to make to me as an emergency measure. As you folks know, I only received these papers just a few minutes ago. They came off the wheel. The clerk's office called my clerk and asked if we had time. I'm fitting you in. I don't have a lot of time to be able to deal with this. I've got about, half an hour, a little bit less. So we're going to need to really be quick about it. So let's get appearances first. This is the case of SV Health versus Manufacturers Best. Counsel for plaintiff.
Good afternoon, Your Honor. Carrie Ann Law from Kramer 11 for the plaintiff SV Health.
Is your mic on, Ms. Law?
It is, I believe.
All right, terrific.
I'll talk really loud.
Okay, all right. And for the defendant, please.
Good afternoon, Your Honor. Andrew Finn from Sullivan and Cromwell on behalf of the defendant, Manufacturers Best.
All right. Now, I was handed papers only from the plaintiff, which is not unusual in this kind of TRO application, just a small statement about why you were here and what you needed. Mr. Finn, have you had an opportunity to review those?
Yes, Your Honor.
All right. So let's go ahead, Ms. Law. Why don't you just tell me what's going on here? I've only had just a very few minutes to be able to familiarize myself with this issue.
Understood, Your Honor. Thank you for hearing us today. We represent SV Health. SV Health is a distributor of PPE products since 2003. So for nearly 2 decades, we have been the exclusive distributor pursuant to a series of distribution agreements for Manufacturer Best. I'll refer to that as MB to make this quicker. It's for MB's product in the eastern part of the United States. The most recent distribution agreement was executed in late 2017 and was to run from early 2018 through the end of 2023.
Right,
So
and
there's
let me
about
just
3.5
ask you,
years left.
Ms. Law, so that I understand this. This is essentially a contract action then?
It is a contract action,
All
Your
right, and-
Honor. However, there is serious harm to our client that cannot be remedied by money damages, which is why we're here.
Okay, but you are, as I understand it, also, you're actively in arbitration?
That's correct, Your Honor. We filed an arbitration proceeding on April 3.
And what's the relief that you're seeking in the arbitration?
We are seeking that the termination of the contract not be allowed.
Are you seeking money damages in that arbitration?
Not at this point, Your Honor.
Okay, all right, you can proceed.
Your Honor, as I mentioned, there was a distribution agreement that had 3.5 years left on it. A couple months ago, we received a notification from MB stating that they intended to terminate the agreement. The timing is a little bit suspect, Your Honor. Obviously, we're now in the beginning of a global pandemic. They have purportedly entered into a deal for an oral agreement with a partner of ours that has left and want a new deal to proceed with them. And Your Honor, they cannot get out of their contract with us with 3.5 years left on it by a purported breach of a best efforts clause, which did not happen.
All right, so that's where that's the core of this, is that there's a purported material breach that they're asserting?
That's correct, Your Honor. And
And-
they claim we have not cured that breach.
And that's a purported breach of this best efforts clause?
Correct.
All right, tell me why, just so we can sort of cut to the chase, we have such limited time. Tell me why there's any irreparable harm here. As you know, I can't do anything unless you can demonstrate to this court that there's irreparable harm. Because
Absolutely.
normally contract actions, there's not a lot of irreparable harm, right? You can get damages for any early termination, material breach, et cetera, et cetera.
Absolutely, Your Honor. In this case, like many cases where one party is denying product to another partner, the case law is abundant that there's loss of goodwill and loss of customers when that happens. And that's exactly what happened here. In the Rex case, for example, which was before this court, it's very factually similar to this case. In the Rex case, there was a medical product that was being supplied to a distributor. The distributor no longer wanted to distribute the product, and they tried to terminate the agreement. Like this case, that case was to be resolved in arbitration. Notwithstanding, the parties went to federal court and asked for a temporary restraining order and a preliminary injunction to preserve the status quo pending the resolution of the arbitration.
And
The
why
court
not just,
granted that.
and why not just go to the emergency arbitrator first? It
First
seems
of
if
all-
you've already started arbitration, then, and you've got the provision in your contract, which I assume you do, it's a relatively standard provision, you'd have the ability to go to an emergency arbitrator. Why not just start there?
Your Honor, there's a couple of reasons why we wouldn't start there. One is This contract ends in 2 days, according to the notice. We want teeth behind an injunction, and we came here to get the teeth behind that, number one. Number two, the law is very clear that notwithstanding that there could be relief sought in an arbitration proceeding, the courts, if we come to you, must hear and must resolve, even if they feel it would be more expeditious to do it in arbitration. And that's made clear in the government versus UK versus Boeing Second Circuit case, in the Rosso case versus Coca-Cola. And in fact, it says the fact that a dispute is to be arbitrated does not absolve the court of its obligation to consider the merits of the requested preliminary injunction. The proper course is to determine whether the dispute is a proper case for an injunction. That's exactly what the Rex case did that I mentioned a moment ago, and what the court should do here.
All right. So you'll get an order from me one way or the other. Are you sure, Ms. Law, that you prefer to have an order on the likelihood of success on the merits? Because as you know, I have to be able to give you either a transcript order that's where my oral remarks are taken as a written transcript, or I've got to give you a written decision. It's immediately appealable to the Second Circuit. Do you want, I'm just asking you tactically, do you want a decision on the likelihood of success in the merits that could actually be a problem for you in the arbitration? You
Yes,
ready
we
for
do,
that?
Your Honor. We actually expect that it will not be a problem with us, that you will find that the facts very much favor our client in this situation when you hear all the evidence and the facts.
Okay, so let's go back then to the irreparable harm. As I understand it, the facts are also, you've talked about loss of goodwill, loss of customers, but when you lose a supply contract, you're always going to maybe have a little bit of a few loss of customers. Why is it, well, actually, let me put it differently. Isn't it the case that this business, this portion of the business that MB, the defendant, represents is only, I've forgotten what it was in the papers, but 9 or 10% of your overall business?
It is a small part of the business, but there's a very important public interest at stake here. SV has been providing customers with this PPE equipment for nearly 2 decades. Our customers expect it. They are making their businesses based on it. We are in the midst of a global pandemic, and now they have pulled the rug out improperly based on the contract from us. And they are denying people with PPE that is incredibly important. In April 2020, if you listen to any of the news reports, they are forecasting that this may go on for a long time.
So you're actually making an argument that the public interest here, which is one of the 4 prongs of the standard that has to be met, you're making an argument that it's particularly strong here. Is that right?
That is correct, Your Honor.
All right. Well, tell me about bond. Now, as I understand it, MB actually has some form of, I don't know if I want to call it an agreement, counsel will tell me, but some sort of formal, informal, oral conversation to have another agreement. That could suggest that you may need to post a bond. Are you prepared to do so?
We are prepared to do so, but we don't think there's any need to do so. Here, with an injunction, MB will simply be required to continue its decades-long relationship with SV Health for a brief period longer. Without an injunction, SV Health faces irreparable harm by the loss of customer goodwill, business relationships, and that cannot be remedied by money damages. The case law is clear that when there is no likelihood of harm to my adversary, a bond is not necessary, and we do not believe any bond would be necessary here.
Okay, one more point that I want you to address, that I'm going to turn it over to Mr. Finn. The best efforts clause here, I just glanced at it just now, says that has to be best efforts to maximize sales, As I understand it, your counterparty to that contract claims that your sales have been decreasing and that there's a relatively easy off-the-shelf product that you could have implemented to increase sales. So how do you actually have a likelihood of success on the merits here?
Your Honor, we have been using the same method to sell the product since 2003. Same method. We have had growth every year except one. Their whole case is because we had 1 year of dropped growth. There are no allegations that we're favoring products over theirs. There's no allegations that we acted in bad faith. There's no allegations that there was delay or sabotage. This is because of 1 year drop. And coincidentally, it's because one of our partners left and started their own firm. And now all of a sudden they want to do work with them. but they have not entered into any formal contract. I know Your Honor mentioned that a minute ago. They have an oral deal, but under the UCC, they have to have a written deal. And that written deal is supposed to be executed in the next couple of days, which is why this relief is so important now.
Okay. All right. Thank you, Ms. Law. Mr. Finn.
Thank you, Your Honor. Now, I just received this application, but I'll try to respond to some of the points that plaintiff's counsel made. There's really no dispute here that the parties agreed to arbitrate this dispute. We already have an arbitration. And there's also no dispute that what the plaintiff is seeking here basically is to end run that arbitration and obtain what they are seeking the arbitration as final relief as a preliminary injunction or TRO here.
Well,
and that is,
as I understand it from having glanced at the contract, which you folks agreed to, the contract actually allows for concurrent jurisdiction for this kind of interim relief between both an emergency arbitrator and my court. So I do have jurisdiction. You're not making a jurisdictional argument.
No, Your Honor, but in a situation like this where everybody's agreed and there's no question about compelling a party to arbitration, the court's role is very limited. And that is there a real need to grant some interim relief pending the arbitration? And that's the standard that the Second Circuit has found to grant a TRO or preliminary injunction. That's why we look at the likelihood of success on the merits in the arbitration. It's essentially to maintain the status quo so that the parties can go and arbitrate. And that's not really what the plaintiff is seeking here. The plaintiff is seeking to hold my client, Manufacturers Best, in a contract that they haven't been fulfilling for the last year throughout a very important time when demand for our product is increasing. While the arbitration plays out, they're essentially vitiating our right to unilaterally terminate the contract after we've given proper notice of a breach, which we have here.
So let me just ask you first about the merits. So the best efforts clause, as I understand it, has this maximize sale language that I discussed with Ms. Law. But you would agree with me, wouldn't you, that that does not mean you get to have the form of sale of your choice, right?
Yes, yes, Your Honor.
You would agree with that, right? And you would also agree with me that you can't just require Ms. Law's client to install the software package of your choice, right?
That's right, Your Honor, nor did we require them to do so.
All right. So are you prepared for a written decision on a likelihood of success in the merits?
Your Honor, we don't think there should be any need for that decision on the merits, but we're happy to entertain it. I mean, the reality here is that this has been bubbling up for over a year. And there wasn't just a small decline in sales. There was a 26% decline in sales in 1 year after a record of increasing sales since the beginning of the contract. So we have a clear record that the plaintiff here dropped the ball. And we gave them notice more than 3 months ago that we thought they were dropping the ball and they needed to remedy it now. And the solution we got was only last month when they said, well, we'll try to implement something in 6 to 12 months. At this time, when we need to get our product to the market, we cannot be tied to a weak distributor.
Okay, so let me just ask you, let's switch to the irreparable harm. So counsel says they're going to lose a lot of goodwill, they're going to lose customers. This is precisely the kind of irreparable harm that the case law does support in very limited numbers of contract cases. Tell me why she's not right.
Your Honor, I think a comment you made nailed it on the head. Every single distribution agreement that's terminated will result in some customer disruption potentially. But courts in the Second Circuit have made clear that when you're just saying loss of goodwill due to a loss of a product in the distribution agreement, that it needs to be a very unique product that you cannot replace. That's one. And then it also needs to be a significant part of your business such that you really cannot go on.
Is that a in the conjunctive or a disjunctive? In other words, does it have to be both unique and it has to be something that your business is going to disappear into the ether because you don't have it? Or can it be one or the other?
I think it can be one or the other, Your Honor. I think when you have some of these cases involve very unique, medical devices that can only be manufactured by one company, others deal with the entire distributor's business is this one product.
So let's just take that one piece, because I want you to then transition into the public interest. Aren't we in an unusual time here? And we don't know what's going to be happening. It's like the morning show. We don't know what's going to be happening in terms of COVID and PPE, but we know we're all supposed to be buying it, and things are hard to get already here in April of 2020. So isn't this almost like that kind of unique product that we're talking about? And then why don't you just talk to me about the public interest? Because it seems like keeping supply arrangements smooth at this time makes that element unusually important.
Yes, Your Honor. So on the evidence of replaceability of the product here, our client manufactures masks and other PPE. There's actually no evidence in the record right now that the plaintiff cannot obtain, something alternatives. Now we think that obviously manufacturer's best is the best PPE out there, but there are alternatives in the market. And on the public interest that also the plaintiff touched on in terms of the pandemic, this issue didn't start during the pandemic. And frankly, it is our business and my client's business to manufacture this PPE. We need a quality, efficient distributor in this market to get the PPE out there. We think we found that distributor, that alternative distributor, and the plaintiff here dropped the ball last year on this distribution agreement. We should be, and the public needs our products. We should be free to contract with who we want to get that to market. All
right. So it sounded like from Ms. Law that contract with whomever it's with, this former employee of the plaintiff, is not yet signed and sealed. So would your client be willing, Mr. Finn, to at least do a standstill for, say, 60 days? Just a 60 days by agreement. I don't have to issue an order. You just do a standstill. You can then continue, solidify your contract with these other folks. And we just deny the motion as moot by agreement and on consent of the parties. Would you be willing to do that?
Your Honor, we'd be willing to wait another 10 to 20 days on the condition that the motion is terminated and we're allowed to continue negotiations with third parties in case the negotiations don't go forward successfully.
All right. So you would give essentially a TRO only lasts, as you folks know, for 14 days, and it can be renewed for another 14 days. That's a total of 28 days for a TRO. So, and I don't expect to have to rule on a PI, because preliminary injunction, because I would assume you'll be fully in the midst of arbitration by that point. So you're saying that you'd essentially go as far as the first portion of the TRO on consent.
With the condition, Your Honor, that we can continue to negotiate with third parties so that we have something in place, because we haven't been able to negotiate anything. And given the timing and the need for our product to get out there, we really need to have something in place very quickly.
Okay. And just tell me before I'm going to have Ms. Law just respond to you briefly, but what's your position on the bond?
Your Honor, if the TRO and preliminary injunction that the plaintiffs are seeking is issued, we need substantial security. We have no assurances given the last year that we can get our product out there. We need to get our product out there. This is critical for us. Our client needs to invest massively to build up its supply. And if we lose our market share in this market because of the plaintiff's inability to distribute our product, we need security for that.
All right. Thank you. Thank you. Now, Ms. Law, I've got a couple of questions from you from what Mr. Finn has said. First, Mr. Finn says the public interest is actually in his favor, that having frankly, what he claims to be a better supply arrangement is going to serve the public interest better than continuing with you. So I'd like you to respond to that. And also to respond to Mr. Finn's essentially his agreement that his client would stand down for 10 days. That would give you 10 days to go out, find another supplier. He'd have 10 days to negotiate his contract, and the world would have 10 days of additional smooth supply.
Your Honor, I'll take them one at a time. With respect to the better supply, I find that a little ironic, considering that he is entering into a deal with a company that has just formed. They have no history. They have no record. They have no record of success. They have just been formed. Unlike my client, who has been distributing this product successfully for nearly 2 decades for them. So for that reason, Your Honor, I think we are in a much better position to supply the public with the needed PPE right now. With respect to the 10-day standstill, I'm happy to take a 10-day standstill to see if we could work out something between us. But if the 10 days is merely to prolong that this contract is going to terminate and we are going to lose access to PPE. You can't throw common sense out the window. Try getting it for your home right now. Try ordering it from Amazon. Everyone is trying to get PPE. You can't get it. It is
Well, now
not
that
going to
just
get
sounds
any
like
better.
you want 10 days extra on your termination clause. Your termination clause had a time, it was a very limited termination clause. And what you're, I mean, I wasn't talking about 10 days for, and to extend your termination clause. I was talking about 10 days to make this motion go away. We terminate it as moot. It comes off my calendar. You folks then, by agreement, you continue to distribute it. And what you do, Mr. Finn, is you negotiate your contract. You'd be out, Ms. Law.
No, Your Honor, we're not willing to accept that.
So you're not willing to do that.
No, Your Honor.
All right. So what you prefer then is a decision actually on the merits.
Yes, Your Honor.
All right. Do you feel like you need to have any additional discovery or anything like that in order to make this happen?
We would like additional discovery of 1 to 2 witnesses.
1 to 2 witnesses,
You can
depositions?
do it depositions in a week.
You could do it in a week?
Absolutely, Your Honor.
Would you agree to have those materials also be usable for the arbitration? I don't want to have
Absolutely, Your
things
Honor.
happen twice. All right, Mr. Finn, what do you say about that?
I think this just goes to show the real purpose of this is to put pressure on manufacturers best. There's no need for discovery here. That should all take place in the arbitration on the merits. And it's more to the point that we should be resolving this dispute in arbitration and not before Your Honor.
And how quickly, Mr. Finn, do you think you'll be able to get this agreement if you had to go lickety split because Ms. Law says that she's not going to agree to the 10-day stand down? How quickly can you get, in your view, an agreement up and running and get your this additional alleged supplier up and running?
5 days, Your Honor.
5 days?
Yes.
You think that they can actually have product in the market in 5 days?
That's what my client tells me, yes.
All right, and they're going to be able to get shipping in 5 days?
They've been working on, as I said, Your Honor, this is not an issue that just arose yesterday. It arose months ago, and they've obviously been preparing.
All right. All right. Well, thank you, counsel. You say you don't need any additional discovery. Ms. Law says she does. Well, why don't we have you take 1 deposition?
Thank you.
Why
Your
don't you
Honor.
take it in the next 3 days?
Will do.
If you can, half day, just a couple of hours. Submit to me anything that comes out of that that's particularly on the issues we've been talking about today, and I'll have a decision for you forthwith. All right, folks?
Fitting us
Thank
in.
you, Your Honor.
Thanks very much. We're dismissed.
So you all are going to be waiting with bated breath for the decision that's going to be rendered shortly. But one thing that we wanted to highlight before we start the next panel is the different standard that may apply in federal court versus an arbitration proceeding under an emergency arbitrator provision. And obviously, Rule 65 of the Federal Rules of Civil Procedure provides that for TROs, they can be granted without going to the adverse party. But for the preliminary injunction, the adverse party has to be noticed. In this mock exercise, of course, the adversary was there, but it's not necessary in federal court to have your adversary there. And you can go in federal court for a TRO without your adversary or being noticed. And the other point that was highlighted there was the need for a security. The rule requires a security. In contrast to the very specific provisions of Rule 65 and the Second Circuit standard for what is required for a preliminary injunction, the various arbitral institution rules have some form or variation of a clause that requires that the emergency arbitrator can grant interim or conservatory measures as it deems necessary, as it deems appropriate, or some have a provision that requires that the party show immediate loss or damage will result in the absence of emergency relief. But the standards within respect to the various arbitral institution rules that might apply are very streamlined and do not set forth in great detail any specific standard that is generally required, and has more loose language in relation to necessary relief or deemed appropriate relief. And that standard is very different and something to consider as advocates advise their clients with respect to which path to take through emergency arbitration or that of a federal court.
And oh, sorry. So the and I'm going to give you the CLE code before we move on to the next part of the session here. It's NY11, New York 11. So we're going to now go to the emergency arbitrator hearing. Unlike the last hearing, this would not be in a public forum. We will see, but I think our emergency arbitrator would be more prepared and have had slightly more notice than the judge in the emergency part in the Southern District. So I'll introduce our participants and then get on with it. For our emergency arbitrator, we have Grant Hanessian, who is an independent arbitrator and who has in the past in real life presided over such proceedings. For our advocates, we have Greta Walters of Chaffetz Lindsay and Jose Sanchez of Vincent and Elkins. So let's take that away.
Good afternoon, counsel.
Good afternoon, Mr. Hanessian.
Nice to see you. I have received your voluminous submissions. I had to clear out some space from my hard drive to download them from the cloud. I particularly appreciate your 40 authorities, Mr. Sanchez. I can't say that I've read all of them completely, but I've read what I hope to be the key ones. Have you discussed the allocation of time today?
We have, Mr. Hanessian. We would like to have 11 minutes each and then whatever is left for rebuttal.
Okay, very good. You've advocated different standards here for the application. I'm particularly interested in your views as the applicable standard and of course whether how the case is resolved under the standard that you propose. You've each submitted witness statements, as I said in the short order that I gave you. I don't think we need to proceed with witnesses at this point. I think there's not any material dispute about a fact that I think is necessary for me to render a decision here, and we'll proceed on that basis. So, Mr. Sanchez.
Thank you, Mr. Hanessian. If I may borrow a term from football, can I get a 2-minute warning, please?
American football, yes.
Yes.
We will do that.
Yes, thank you, Mr. Hanessian. All right, Mr. Hanessian, there are two issues you need to decide to actually rule on this application, and those issues are very clear. Number one is, what is the applicable standard? And number two is, do we meet the standard? Does SV Health meet the standard? Let me tackle the first issue, which frankly, I believe at this point should be undisputed. What is the applicable standard to a request for interim relief in front of an emergency arbitrator? As you know, the rules don't have a standard, so you must apply either New York law or the international standard. The better practice is to apply the international standard. And I want to be clear on this. You've got discretion to choose either one, but the better practice by far is to apply the international standard. And that's not just me saying it, as you know, that is in my article that I know you've read, but that's not just the only authority saying it. There is a majority of the emergency arbitrators around the world ruling on this request are applying the international standard, not the domestic standard, and for good reason, right? International arbitration is moving away from local procedural rules that tend to be more parochial.
Well, let's talk about the differences between the New York standard and what you're calling the international standard.
Appreciate it. Thank you, Mr. Hanessian. We'll get to that in a second because that's actually the heart of the matter, isn't it? As a matter of fact, the international standard is significantly lower than New York standard. Where is that international standard? It's Article 17A of the UNCITRAL model law. And that should also be undisputed at this point. Most emergency arbitrators agree with that. Most authorities agree with that. And if my opposing counsel disagrees with that, it could be kind of a moot point because ultimately the standards are very similar with respect to the international standard in the UNCITRAL model law or some other kind of international standard. Whatever international standard you apply, however, is significantly lower than New York law, significantly lower. So let me get to the international standard in Article 17A of the model law, which again is the one widely applied by emergency arbitrators around the world. Under that standard, we, SV Health, to obtain interim relief, we must prove a few things. Number one, that we're likely to suffer a harm. that harm is not adequately reparable by an award of damages, that harm substantially outweighs the harm likely to be suffered by the other side, and that we have a reasonable possibility of success on the merits of the claimant issue. We meet all those elements. And I will go through that standard in a second, but let me underscore this from the beginning. Even if you apply New York law, we still meet that standard by far. So let me start with the harm. Harm likely, we're likely to suffer a harm if the injunction is not granted. Absolutely. There's no dispute here that we're going to lose our client relationships, that we're going to lose our goodwill, that we're going to lose market share, that we're not going to be able to fulfill the purchase orders that are now outstanding from our clients. The fact
It's a relatively small market share, correct, of your overall business?
I'm sorry, say that
It's a
again?
relatively small amount of your overall business, right? It's 5 to 10% or so?
Yes, and I'm glad you asked that question because it's an argument that has been made by the other side, which is frankly irrelevant. It is a small margin of our business as of now. The pandemic is significantly going to change that because now we have the hottest commodity in the world, PPE products, right? But we are still likely to suffer a harm. It doesn't have to be the larger part of our business or the largest part of our business to be a irreparable harm. So we will suffer the harm. I will get back to this. I will go back to this issue of the 8% of total income as part of the irreparable harm standard. But now that we've discussed that we're likely to suffer the harm, let me show you how that standard, that harm is actually not adequately reparable by an award of damages. And two things to say on that, Mr. Hanessian. First, the language not adequately reparable by an award of damages under 17A of the model law is significantly lower than irreparable harm under New York law. And it covers two things. One, harm that is not economic in nature or that cannot be compensated with money, and also harm that could be compensated with money theoretically, but would be very hard, or to quote the travaux préparatoires of the model law, comparatively complicated to calculate reliably. We actually meet both prongs because we would suffer harm that is impossible to calculate monetarily, say goodwill, loss of customer relationships, say market share. Let me pause there for a second. The Second Circuit itself, if we wanted to apply New York law as well, the Second Circuit itself has made it clear, this is a 2002 case that we cited for you, that if you lose an ongoing customer relationship that would prevent you from income for years to come, that is impossible to calculate, that's actually irreparable harm. Because it's irreparable harm, it's of course harm under Article 17A, which is a lower standard. But we would also suffer harm that is hypothetically easily calculable, but can never be calculated reliably. For example, the orders that we were going to get from these customers for the 3.5 years that are left in the contract. As of now, we have customers that will get this product from us until December 31st, 2023. That's going to make our company some profit. And there is no way to calculate that specific profit. Opposing counsel has told you that, well, this contract has been ongoing for the last 17 years. So all you do is you average out the profit per year, and then you just multiply it by 3.5. Well, that argument is flawed for two reasons. One is we are now selling a lot more PPE product and will be selling a lot more PPE product than ever because of the pandemic. The pandemic is an act of God and is not something to be celebrated for our business. However, it's great. It's great business.
Won't MB sell the same amount of the product? And can't we just, if you were to prevail in the arbitration before the regularly constituted tribunal, which I am not,
yes,
but wouldn't they have that information available and you could be awarded damages on the basis of the actual sales of the same product?
Not necessarily, Mr. Hanessian, because you're not comparing apples to apples there. You wouldn't be comparing apples to apples. They don't have a supplier to distribute those. That supplier would be an unproven supplier. There's no way of knowing if we would actually have sold more than they do. And more importantly, there is no way of knowing what profit margin we would have made on those products, because now the product is a hot commodity. We can sell a lot more.
Wouldn't be gouging the public.
Well, within reason, of course. I'm not advocating that we're going to engage in price gouging. Of course, I understand that. So our harm, not adequately reparable by an award of damages, needs to be contrasted with the harm that they are likely, and I quote the standard, they're likely to suffer. And when you look at the harm that they claim they're likely to suffer, the answer is that there is none. Because all they have is a verbal agreement to enter into an agreement with another supplier. Let me say two things on that. That's not a likely harm. That's speculation at best, because there is no contract. There is the intent to enter into a contract in the future. As a matter of black letter New York law, that's actually unenforceable as an agreement to agree. That's actually lethal to their claim that they have any kind of harm. More importantly, however, that is not in writing, so it doesn't meet the statute for requirement of the UCC. So they don't have a contract as of now. All they have is a business lead that may result in the possibility of selling product to someone else. That's not likely. That's speculative harm at best. Compare that with our certain irreparable harm that cannot be compensated with money. The balance actually tips decidedly in our favor. Substantially, our harm outweighs the harm that they are not even likely to suffer. That is actually the third standard or the third element of the international standard. Harm not adequately repairable by an award of damages that substantially outweighs the likely harm to the other side. Unless you have some questions on that, I would like to move on to the merits point in a second.
Please.
Thank you. The final element is a reasonable possibility of success on the merits. And let me start with something very clear. Reasonable possibility under the international standard is significantly lower than likely. It's actually significantly lower than 50%. It's slightly above an arguable claim. That's all we need to prove. We don't need to prove strong likelihood.
What is the basis for that interpretation
of course,
reasonableess?
Well, it is. I hate to cite myself, but it is actually in my article. It is actually in my article citing to the travaux préparatoires of the model law. As I explained, Mr. Hanessian.
I do have your article in this voluminous submission you've made. One second. Oh, yes, here it is. Okay, what page?
Yes, if you can give me a second.
And this is your 2-minute warning, but there's no timeout. There's no timeout, as there is in U.S. football.
Right, that's actually 73 and 74, and I'm citing to the travaux préparatoires, and I'm citing to the emergency arbitrators that have issued relief under the ICC and the Stockholm Chamber of Commerce.
I'm sorry, which page?
Pages 73 and 74 of my article, citing to the relevant authorities supporting it.
Okay, very good.
All right.
All right, please continue.
So we have at least a reasonable possibility, and I will say a strong possibility of success on the merits, because our claim is that there is wrongful termination. We succeed on that claim if we can prove that they terminated the contract incorrectly, and we will prove that for two reasons. One, we did not breach at all. There is no breach of the best efforts clause. At most, there is some allegation, speculative allegation, that if we had issued or used some kind of new software, we would have sold more in one specific year. But there's no proof whatsoever that different software would result in higher sales. Second, even if they were to prove that that's a breach of the best efforts clause, is not a material breach of the contract. Under New York law and under the contract, for them to terminate the contract, they need to prove that that is a material breach of the agreement. Material breach is one that goes to the root of the agreement, a breach without which you would not have entered into the agreement to begin with. They cannot begin to argue that they would not have entered into a contract with us if we had not agreed to 18 years later into the contract issue new software that may or may not result in higher sales. And one more thing, it's just speculation that that best effort clause has been breached, because actually it's inconsistent with our business model, which has resulted in significant gains for them in this market for the last 22 years.
Until last year.
Until last year, yes. At which point,
when the sales declined 26%.
Yes, and those are the facts. And I should mention that the reason why is because there is competition in the market. There is additional competition, not because there is some software that we should be using, which no one has demonstrated is better.
That's time. Thank you very much.
Thank you,
We'll hear from you in a rebuttal. Ms. Walters.
Thank you, Mr. Hanessian. I'm going to try to keep my own time, so apologies for having my phone up here. So I want to take a step back before we get into the factors that you, sir, should be considering on this application. And that's to go to the question that you asked us to address first in these arguments today. And that specifically is, where precisely do we find the source and content of the international standard for emergency arbitration applications? Now, the question itself hints exactly at the problem with the position that SV Health is asking you to take on this application here. And that is that there is not one international standard that does or even should apply to emergency arbitration applications in general, or more critically, specifically that should apply in this case. So if we first look at the potential sources of a standard of international law, Mr. Sanchez has directed you to the standard in the UNCITRAL Model Law, Article 17 as that standard, and I'll come to that in a moment. But this is not the only place we could be looking at this. There's a number of places we could go to find an international standard, which I understand is why you asked us this question. For example, we could look at the various arbitral rules out there. For example, if we look at the ICC rules, there is actually no specific standard. If we look at the ICDR rules, there's a standard of necessity. If we look at the JAM rules, there's a standard for immediate loss or damage. If we look at the AKICA rules, there's a detailed three-part test that differs from the one laid out for Mr. Sanchez, but is actually very similar to that under New York law. Now, we're obviously not under these rules, but they are some of the most widely used rules in international arbitrations. And they make plain that there is no agreement, even in the international arbitration community, as to what one international uniform standard on emergency applications is or should be. But second, if we look at actual international practice on EAA applications, this also confirms that it's true that there is no one international standard being applied. For example, in the ICC's 2019 comprehensive report on EA proceedings, which claimants have referenced in their submissions, the task force identified that in nearly 1/3 of the cases studied, the emergency arbitrator did not use some amorphous concept of international standard to decide an application. But even in those cases that the task force identified as using a standard not strictly rooted in domestic law, there was no one standard applied. The report identified at least 5 different factors that were considered, and all of the arbitrators didn't consider those. And even for the most common factor, a risk of some sort of harm, which, by the way, only 50% of the arbitrators considered, it wasn't applied the same way. The report identified at least 3 different ways that that standard was defined. And it also noted that practices under the SCC, for example, AKICA and SCAI, applied it entirely differently. So the question that you asked us to address, what is the standard and where do we find it? The answer is nowhere, because it doesn't exist. So claimant's admission that we can just easily adopt the UNCITRAL model law standard simply isn't the reality of the world that we're operating in.
So you don't agree that the model law 17A is a consensus standard?
I absolutely do not agree it's a consensus standard. The practices and rules don't reflect this. But critically,
you don't agree with Mr. Sanchez's article?
Well, I will come to Mr. Sanchez's article in a moment. And I'm happy to cite Mr. Sanchez's argument, actually. And the critical thing is I've studied Mr. Sanchez's article, and he argues for taking the model law approach in the interest of uniformity. Now, what I haven't heard him explain, and I don't think he could explain, is why we have a goal of uniformity here. There's a private commercial case between 2 private parties that have chosen to arbitrate in New York with a contract subject to New York law and under New York administrative rules.
You agree there's no guidance in New York law here, New York statutory law, right? The CPLR Article 75 doesn't help us here, and the Federal Arbitration Act doesn't help us here. There's no standard in New York arbitration law we can apply here, correct?
If you look strictly at the code or the statutes, correct, that I would agree with that. But to say that there's not guidance in New York law, I wouldn't agree with that. We do have a standard for interim relief under New York law. And a case like this, where the parties have overwhelmingly selected a New York framework to govern their dispute, there's simply no reason why they would choose, or why you, sir, should adopt an UNCITRAL model law standard to do so. If the parties wanted to arbitrate in a model law jurisdiction, they could have chosen Singapore. They could have chosen Singapore law to apply. They didn't do that. They chose New York, which is not a model law jurisdiction, and New York law gives us a perfectly good framework for interim relief that can be used here. So with that, what is the standard? Well, New York law has been clear for many years now that the party requesting interim relief, so SV Health, must bring evidence on 3 things. First, irreparable harm. Second, a likelihood of success on the merits. And third, that the balance of hardships tips decidedly towards the party seeking the measure sought. Now, it's worth emphasizing that SV Health bears this burden. They must bring the evidence to advance their claim. The reason for this is that courts in New York have long recognized that preliminary injunctions are one of the most drastic tools in the judicial arsenal. arsenal, and it should not be granted lightly. So turning now to the third issue that you asked us to address, and that's whether SV Health's application has met the New York standard, or alternatively, an international standard, whatever that may be. And the answer under any standard is no. Now, I wanted to focus, in the interest of time, just on the harm standard. But to be clear, SV Health hasn't met any of these three elements under this. And I want to just maybe respond to one point that Mr. Sanchez made regarding the materiality aspect here of the underlying breach, which goes to the likelihood of success on their merits. The suggestion that the best efforts clause was not material to my client is just divorced from reality. My client, Manufacturing Best, entered into an exclusive supply agreement with SV Health. This means that our only customer was SV Health. If they didn't use the best effort.
I have that point. I don't think you need to
Okay,
address that.
thank you. Okay, thank you, sir. Well, let me go to where I had planned to talk to, and that's about the irreparable harm. Now, Mr. Sanchez admits they don't want New York because this is a higher standard. And in reality, they cannot meet it, and they haven't under this case. So what is the harm that SV Health is alleging? Two things. First, that termination of the contract would mean that SV Health could not fulfill some of its customer orders. And two, that there's a loss of goodwill to some of its customers. Neither of these are sufficient under New York law. On the first point, the fact that SV Health may not be able to fill some customer orders is entirely speculative at this point. SV Health has not offered sufficient details on when their alleged customer orders may become due, on the quantities that potentially we're talking about, the volume of PPEs at issue. We don't even know if they actually exist. The absence of these details is particularly relevant here because SV Health's sales of Manufacturing Best goods has been steadily declining for 2 years, 26% in the last year alone. We don't know if there's what the demand is currently for Manufacturing Best goods from SV customers' health. And again, SV Health bears the burden of showing what that harm would be. Moreover, SV Health has not sufficiently shown that it would not be able to get the PPE from somewhere else if the contract is terminated. We don't know if
on that, I mean, we have to consider our circumstances here. This is a historically difficult market for PPE. We have this unprecedented public health emergency here. So if these are available, and that's questionable, I think I can take that into consideration. The price will be astronomical compared to the prices in your contracts, correct?
Two things, Mr. Hennessian. The prices may be astronomical. They might be more. We don't know because SV Health hasn't told us what they've tried to do or haven't tried to do to get a cover purchase. So we simply don't know that. But if the price is astronomical, this is money. This is not irreparable harm. They can easily quantify this amount of money by comparing the new purchase price against what they say they would pay us. That's not irreparable harm. That can be awarded by money damages. And this is precisely what New York law says does not justify
You don't think they would lose customer relationships to your new supplier that would take over those relationships, particularly since this has been a former 50% shareholder of the claimant here?
Well, again, I would take issue with whether SV Health has shown this to be a reality. But even if they have shown that they would lose some customers, New York law is clear that some customers, even the 8% that claimants reference in their papers, this is not enough to constitute irreparable harm to justify relief.
Well, that's a pre-pandemic 8% though, correct?
It is a pre-pandemic percent, but that raises another issue in Mr. Sanchez's argument. We have tried to work with SV Health and ask them to improve the material breach of the contract. They chose not to. Instead, we identified exactly the way to fix the issue and how we can go and fix it going forward. They instead said, no, wait 6 to 12 months, then maybe we'll get to it. Now we've heard Mr. Sanchez say repeatedly, they're excited to take advantage of the pandemic and increase their profits. This isn't what we agreed to them. We agreed to a contract that if they did not fix a material breach, that we were entitled to terminate it and find a more appropriate and a better partner. They can't say that we're not allowed to do that now just because they're expecting to get a windfall due to a global pandemic.
Just before you close on your initial presentation, could you talk a little bit about your request for security here in this case?
Did we request security? Sorry.
Well, I think you should request security.
Sorry. I just want to make sure I'm not missing something. Yes, Mr. Hanessian, thank you for raising this. And that is the last point I had planned to end on today. We do have to be mindful of the situation that we are sitting in today with the global pandemic. My client is active and has lined up another customer for its goods. We're ready to sign that contract, and we're ready to move forward with selling our products to get our products out into the market in this pandemic. We stand to suffer significant harm if we're prevented from doing so, to go forward with that contract and continue to sell our goods in that market. So if in the alternative, if this application is warranted, we would ask an order for security be issued to cover the likely damages that we would suffer as a result of the preliminary injunction.
All right. Well, maybe give some thought to the exact amount, which we can come back to a bit later, perhaps. Mr. Sanchez.
Thank you, Mr. Hanessian. Is this on?
Yes.
Yes. Thank you, Mr. Hanessian. Let me start with that last point, the request for security. It should be undisputed that that's not applicable here. That's a New York law requirement. That's not an international standard requirement.
I'm not prohibited from granting security.
I agree with that, Mr. Hanessian, but I would say that you've got discretion to impose that requirement. We respectfully submit that you should not, because it's not the best practice. That's a procedural requirement of New York law that is not applicable to this international arbitration. In fact, Mr. Hanessian, I read with great interest, and I thought that was a brilliant decision, your award that was subsequently published in the Rocky Mountain case, in which you yourself deviated from New York procedural rules because you found that this was an international arbitration that did not require you to follow those rules.
That did not concern security, correct?
Correct. It was a procedural rule, just like the requirement for security is as well. But even if we were to conclude that requirement for security is somehow justified, let me say two things on that. If you ultimately grant security, that should absolutely tip the balance in our favor. Because under Article 17A of the model law, the travaux préparatoires and the decisions that have applied it by emergency arbitrators around the world, the grant of security or the posting of collateral actually ultimately tips the balance in the substantially outweigh element. So if you feel that security is justified here, I would like to underscore that that is the balance, that is the ultimate element that tips the balance completely in our favor. But there is a big reason why you should not issue an order for security, which is your order is going to be temporal by its own nature. Your order is only going to be firm until an arbitration tribunal comes and is asked, if they ask it, to reverse it. So it's a matter of weeks, maybe at most a month before we constitute a
It
tribunal.
can take more than a month to constitute a tribunal under these New York rules, as I understand.
Let's assume that it takes more than a month. It's going to be temporal by definition, and it's not going to take several months. And we're going to collaborate with them to constitute that tribunal expeditiously. The point being, because it's going to be short-lived, if they want it to be short-lived, they can ask for it to be rescinded in front of the full tribunal. There's no need for security. It's limited.
The security could cover, we're in this historically hot market for this product. It could cover the period between the date of the order and the date that the fully constituted tribunal revisits it, if they choose to do so.
And if that's
or extend it and have more security on the same basis. I mean, it would be up to the tribunal how to proceed, but I agree. It could be a relatively limited period of time, but it could still be a significant amount of money given the market.
We understand that position, Mr. Hanessian. We respectfully believe there is no need to do so, or it would be inappropriate to do so. Let me quickly respond to some of the arguments that were made. We are accused of not having shown that we're not able to obtain PPE from other sources. That's absolutely not true. Let's not forget that MB is our exclusive, and I underscore the word exclusive, supplier. We don't have relationships with anyone else because MB came to us 3 years ago and said, you can't have supply from anyone else. They are our exclusive supplier. So how is it that they can now argue that we may have other relationships with other people that may give us that product? That's just not reality. Additionally, they themselves concede in the fact pattern that it would be, and I quote, extremely difficult to obtain the PPE from other sources. What does that even mean, extremely difficult? 95% chances that we don't obtain it, 92% chances, 97% chances. That is certainly way above the standard that we need to meet here, which is just likely that we don't obtain it. They also tell you, Mr. Hanessian, that there is no international standard because Article 17A is not really an international standard. Suffice it to say, Mr. Hanessian, Article 17A was issued by UNCITRAL after more than 100 countries sent delegations to negotiate what the standard should look like. And 100 delegations from 100 different countries exchanged numerous drafts of that article. I can't think of anything more international than that. And to the extent that you decide that that is not really the international standard, but some case law in international arbitration is the international standard, is very, very, very similar, with one exception. If you apply case law from arbitral tribunals instead of Article 17A, that case law would tell you that you need to consider the aggravation of the dispute. And if you apply that element here, that should be another reason why you grant the injunction. Because if you don't grant the injunction, this dispute is going to be completely aggravated. They're going to terminate the contract. They're going to have another supplier. We will never know how much we would have sold. They would never know how much they would have distributed, and so on and so on.
Well, on that point, you will know how much they will have sold. I mean, your case will continue, I take it. And you will have, there's a liquidation element to the damages to the extent that you have their sales with their new distributor, correct?
Well, but you would be comparing our record of sales, which has grown for 22 of the last 23 years, to the distributor that they say they might appoint, because who knows if it's going to happen. Mm-hmm. That has not proven track record, does not have the distribution channels that we have set up, does not have the customer relationships that we have set up, and so on. So it's going to be complete speculation. That's why you could never compare those two things.
All right, thank you very much, Ms. Walters.
Thank you. Just 3 brief points, and I'll take them in reverse order from that what Mr. Sanchez just mentioned. The concern of the record of the sales being uncertain. We have records of sales for many, many years now. The only reason that there's truly any uncertainty here is because they have breached their obligations under the contract, and they've started to fall in the last 2 years. That's what's changed, and that's exactly why we're terminating the contract. We can't rely on that now to say that this is also the reason that they can get this unusual relief. Second, back to the international standard point. While the UNCITRAL model law very well may have been adopted by many countries, it has not been adopted in New York or in the US where the parties are.
I'm very well aware of that.
And just to do one more point with this, the idea that this is some international standard, in any event, Mr. Sanchez has just offered yet another factor we should consider under it, aggravation of the dispute. That's not in the model law, and it just goes to show that there is not one standard. And finally, on the issue of security, I'll just make the point and close with this, is that claimants are here because they're saying timing is so critical. They need this relief now because of the most imminent harm that's happening to them. Timing is critical for us too. We can't wait a month and deal with this later. If there is any preliminary issue order granted here, there has to be security because there are losses that we will suffer immediately.
Yeah. Let me just ask you one further thing. So there will be a tribunal constituted. I don't know if it'll be a matter of weeks or a month or 2. But eventually you'll have a tribunal. Eventually you'll be able to, whatever I do, you'll be able to revisit that with your regularly constituted tribunal. Balancing the hardships between these 2 parties during that interim period, why would the hardship be greater on your client than on SV?
Well, the hardship would be created on my client because we've complied with the contract. We gave SV Health the opportunity to cure within the contractually agreed cure period, and they didn't. They waited till the 11th hour and now are trying to stop us from pursuing our business interests that we're legitimately entitled to pursue elsewhere. As Mr. Hanessian, you've raised, as Mr. Sanchez has raised, this is an unusual market we're in right now. We don't know what tomorrow is going to hold. We don't know what May is going to hold. We don't know what the next year is going to hold. We have an opportunity to find a replacement partner right now on terms that we could execute immediately to get our goods out to the market. The future is uncertain, to be quite honest.
Okay. Right, thank you both very much. I'll give you something in writing tomorrow, so you'll have it a day before your deadline. Thank you again.
Yeah, I think we should probably, yeah, we can do that.
And then while we're kind of moving around, I'm going to give you the second CLE code, which is AW16. That's Arbitration Week 16. And so what we're going to do now is we're going to have Judge Forrest and Arbitrator Hanessian give us what their decisions would be. And then we'll follow that by discussion and some questions from the audience. So Judge Forrest.
Let me see if I can. How do I get this one? There we go. All right. So what I would have done in this case, I think, is different from what I would have done in many breach of contract cases. In almost all breach of contract cases, I would have, Ms. Law would have had a very tough time convincing me that there was, in fact, irreparable harm. This is, although I think likelihood of success in the merits, you know, it's sort of, who knows, there needs to be a factual record. That wouldn't have been where I would have really paused. But we had an unusual case here where the public interest, this is one of the few cases where the public interest was really at issue. And it's also at a time that was unknown. So what I probably would have done, which is what a lot of federal judges try to do in TRO situations, is try to punt it. And so I would have given, I had a little written decision here, I would have given Mr. Finn a short period of time. He said 5 days. I had 3 days down in my notes to actually solidify his contract with the other side and report back to me. And if he did, then I would have denied the TRO on the basis that the public interest had been satisfied if there was a contract in place. But if he was unable to do it, then I would have granted the TRO because I think that the public interest was so strong in terms of keeping the smoothness of the supply relationships. So in the meantime, what I probably would have done was get them to agree that there'd be a standstill for the 3 days or the 5 days, just to sort of make sure that nobody was hurt in the interim. But that would have been my resolution. So essentially, nobody would have won or lost just yet. There would have been an attempt to try to pull things together to try to really make sure that there was no real imbalance.
Yeah, it's interesting that I don't think I'd ever really thought about this before, but there is no public interest component in the standard that's applied in international arbitration. Why is that? Because it's between the contractual parties. It's a private process. And in the model law 17A and the other potential standards, this public interest isn't really part of that. It's what is a big part of that is balancing the hardship between the parties. Once you crossed a threshold, and it's a question how high that threshold is of likelihood of success and harm. And the harm is tricky, but here where you have this critical product and you've lost customer relationships because you're unable to provide this product, and this competitor now has access to all your customers and market and is able to provide that product, to me, I think that's likely irreparable harm even under the New York standards. So then you're in this issue of balancing the hardships until a tribunal is in place, right? The job of the emergency arbitrator is really just to get the parties to the tribunal. And I know this can take a couple of months depending on the circumstances. But in this case, I think balancing the hardships, I think I would probably grant the relief and maintain the status quo, which is actually a phrase that didn't come up somehow in our conversation. But to me, I would maintain the status quo. I'd maintain the agreement until they had their tribunal in place.
Would you require them to post security?
Well, the amount of, I think I probably would, because the merits here don't seem that clear to me. I'm not sure where this would go on the merits. But calculating this would require some work, and I may have ambushed Greta a little bit here. But that's something that the parties could calculate quickly, and if it was requested, I would. I don't think, as was said, there's any prohibition on me doing this. This does come up in arbitrations where there's a request for security.
Can I also just say that I think that all four of the arguers did a terrific job, just an absolutely terrific job, and we're so prepared for this exercise. It was a pleasure to have had you in my courtroom.
So
it's the same, absolutely the same.
absolutely. And how about for our judge and our emergency arbitrator? before we have a sort of a Q&A session with the panelists that are here, we wanted to raise a couple of other issues for consideration that go into, advocates and emergency arbitrators looking at the issue of deciding between emergency arbitration or a federal state court for relief, interim and conservatory measures. One of the issues that is a key issue for consideration is what type of relief do you need? Do you need permissive injunction? Do you need a mandatory injunction? Are you asking them to do something? Are you asking them to refrain from something? And consider whether or not that type of relief is available in the forum. As was noted throughout the conversation, as well as the argument that was presented, the parameters around what is available in emergency arbitration is vague and opaque, often much more solidified under the federal rules and what the judge can grant and the standard, whether it's permissive or mandatory. A second sort of consideration factor that comes into play is sort of the timing of when you can obtain a decision. And that goes to the issue that we talked about earlier about going in for a TRO without your adversary potentially, although judges don't really like that, I'm sure.
Yeah, I have to say, you get these all the time, TRO applications, and I would make people wait in the courtroom while they called their adversary so that the adversary could come. There were very few instances where I really felt that it was necessary to do it ex parte, and I felt that sometimes people were being ambushed. And so I would just say, okay, just hang out for a little while, call your adversary, get them in here, give them a copy of the papers, and I'll see you folks in 2 hours when they've made it up to the court. So I didn't like ex parte civil applications.
Yeah. And I've never done one. I've always brought the adversary in to make sure I didn't end up in that scenario waiting in the hallway where the judge is like, you know who the lawyer is and you didn't call them? Absolutely. But as opposed to the potential for going in immediately and getting that relief same day, even if you have to wait for your adversary, the judge will wait for you to rule on the TRO or bring your adversary in, maybe get some additional information. In contrast, for the emergency arbitrator situation, there's a process. You've got to commence the arbitration, make sure that you've filed the application, submitted the papers. The emergency arbitrator is then appointed by the appointing organization, the arbitral institution, and then from there, take some time to get a decision, more akin to a preliminary injunction, as opposed to a TRO. So, considerations of how much time you have for the emergency relief and whether or not you need something immediate to get you to a point where you could either have a preliminary injunction hearing or an emergency arbitrator ruling. And then there's a third factor that we discussed as we were preparing for this: confidentiality. Do you want to be in a public forum? Do you want to have the public available? Do you want to have access? And while there is some sealing of documents and certain things, obviously the public nature of the forum versus the confidential nature of an arbitral proceeding in which the emergency arbitrator is the only one going to be present for the discussion, the argument, is another factor for consideration when you're considering whether or not to choose a judicial route versus an arbitral route. And Lee's going to talk about a few of the other factors, and then we'll open it up for questions.
Yeah, and so another one is availability of appeal. And as Judge Forst mentioned, you could go right to the Second Circuit. In the emergency arbitrator context, your probably best bet is going to be to wait for the tribunal to be in place. People have tried to go to court to try and get emergency arbitrator orders set aside. It's not usually very successful. So you don't have the ability right away to get somebody else to look at it. The other big factor with respect to court is the ease of enforcement. So if you need to be able to enforce the decision against a third party, such as a bank, for example, you need to get money or you need to order somebody else to do something, then that entity is not going to be bound by the arbitrator's decision. You're going to end up in court anyway trying to get that enforced. So in those kind of situations, people often make the choice to go directly to court so that they've got something that then they can go take to the third party. We talked about the security and the availability of sureties and security. And then the final issue is costs. If you're in court, of course, in the United States, you are never going to get your costs for the application on either side. In arbitration, you may get to the end and you may be able to recover those costs depending on the rules and the arbitrator. So those are sort of all of the factors that people need to weigh when you're making this decision, often on a very expedited time frame about where to go to seek your relief. And I think with that, we're gonna we may go a little bit longer because we started late and there's not a program out right after this. But so if you're interested to stick around and have some questions, we'll do that. And so let's see what we have. We'd appreciate if you keep your questions short and that they actually, like Jeopardy, they actually be a question. So why don't we take a few? Yeah, do we have the microphone the walking microphone?
I think, yeah.
Yeah.
Great. Yeah, and if you, when you open up your question, just state your name and your affiliation and then ask your question.
Yeah, hi, I'm Hunter Carter at Aaron Fox. Judge Forrest, I had a case before you with many of these same facts. We didn't apply for injunctive relief, and boy, am I glad. Pardon me. I was interested in your concern for the effect of the likelihood of success in the merits aspect of your ruling on their case as it would go down the road. Was it any different than it would have been if the entire case was going to remain with you?
It was different because if the case was going to remain with me, I know that ultimately I would be able to put language around it saying that any ruling on a likelihood of success was done without a full record, and there'd be a bigger record that was developed during discovery, yada, yada, yada. But sometimes there's an interim effect because part of what you're trying to do is to say to the plaintiff, you really want this? Because if you get a written decision or a announced decision that allows it to be appealed because it is an appealable order, then you're going to get a first read on likelihood of success. And you may not like that first read because my first read here would have been, it's not a robust showing on a likelihood of success, but probably enough to show serious questions as to issues that should be litigated, something like that. But it wouldn't have been a ringing endorsement of the plaintiff's claim.
Mark Goldstein. My question also will go to Judge Forrest with a little bit of background. If we go back to the good old days or bad old days when some of us were first growing up in the field, there was actually controversy and division in the circuits about whether an injunction in evade of arbitration was permissible in an international case governed by the New York Convention or arising under the New York Convention. And there was an old Third Circuit case called McCreary, and there was a Second Circuit case called Meiji Milk, which I think was in 1980, which was a pioneering case actually in the Second Circuit saying it's okay. And the rationale was, well, you're effectively protecting the jurisdiction of the tribunal to deal with the merits. And so it's a pro-arbitration thing to do. And yet in the law, as we've heard today, in terms of likelihood of success on the merits, the law as it's evolved on likelihood of success has not been along the lines of protecting the ability of the arbitrators to deal with the merits, but how would this court deal with the merits if we were deciding the merits? And that's where the likelihood of success standard comes from. I think there's still hope for revision of that standards in the courts, and I wonder why it hasn't evolved in that direction, or why you think it hasn't evolved in that direction in cases in your courthouse.
I mean, you raise a terrific point, which is that the different standards become outcome determinative, right? And as you saw it here, it was outcome determinative because ultimately, had I been absolutely pushed on irreparable harm and everything else, and had I think that here the plaintiff won, and here the defendant was much more likely to have won because of the differing standard. But with that public interest piece layered over it, the reality is that district courts don't like to deal with matters that they know are going to arbitration. Because they don't feel like this is somebody else's problem, and they don't also want to interfere with the decision making that will be going on in a very different process. It's the product of an agreement between the parties that everybody sort of came together, and now you're taking it to the court. So that's why there's a real effort, I think, to try and not have it not have it be fully resolved in the district court. But I agree with you. The standard is it's just different. And I don't know of any movement to try to say that when you're dealing with an arbitration issue, you should change the standard. That would be hard because you could still go to them for a PI. And then you've got the PI, and then that's appealable to the Second Circuit. So it would require a whole cascade of differing standards, but it's an excellent point.
Yep, Guido.
Yeah, thank you. Thank you for an excellent panel. Now, very briefly, I wanted to come back to the idea, what do we mean by international standard, which is quite tricky. Generally, I mean, among lawyers like ourselves, international means international law. So we must find something international law. International law comes always from governments. I'm stating the obvious. So any source of international law, it's either a treaty or customary international law. They're both made by governments. So to make a long story short, in this example, I completely agree with you. I mean, the only international standard and international law, although it is soft law, it is not hard law, it is not a treaty, it's just a model law, is the Article 17A of the UNCITRAL model law. I mean, if we are looking on commitments by governments worldwide, all we have is an international instrument, which is in this example in the UNCITRAL model law. If we refer to, Greta, your reference to, I mean, of course, I'm not getting into details, but the reference to the fact of the parties having chosen New York law, fine, but that has nothing to do with whether or not an international standard under international law, although only soft law exists or not. It's a different cup of tea. Also refer any reference to international awards. Most awards are not known, are confidential, with exceptions like ICSID awards and all of that. So we don't know about that. We cannot. How can we say international arbitration practice takes this standard or this standard or this standard? Nobody knows. Nobody has that info because most of the words are just confidential. So what we know for sure, it's only what governments do within the UN, which is UNCITRAL. That's all. Thank you.
You need a subscription to Jus Mundi.
And it gives rise to a point that we raised earlier, that when you're drafting an arbitration clause for an agreement, you may want to consider whether or not to put in a standard for emergency relief, since the rules that are out there do not set forth a standard. So it's a consideration as you advise clients in drafting arbitration agreements and clauses.
And I think we have.
Can I add one thing to that? A lot of contracts do provide for the parties' agreement that a breach is irreparable harm. You do see that, and having sat in some cases where that's been present, that makes it a lot easier for the tribunal. So if obviously it's a drafting issue, but that's very helpful for these cases.
I would add one thing to this, which is I don't think anyone can argue that that Article 17A is the only international standard. I think you can argue it is codified as the most widely used international standard. It is for lack of a better word, the best international standard, or the most commonly cited to international standard. But when she makes the point, well, there is case law from the International Court of Justice or other tribunals that use a slightly different standard, that's true. And all you can say is, but the truly international one is the one by UNCITRAL. What's helpful about that standard is because it's the same language. You can actually see with the Stockholm Chamber of Commerce and the ICC and other institutions that release a brief description of those applications for emergency arbitration, how tribunals have been using that standard. So it gives rise to a little bit of case law that you can follow and then can apply more easily than the other ICJ standards from the old days. On top of that, you mentioned the ICSID cases. To the extent they applied the UNCITRAL rules, that's the exact same standard that you would have under Article 17A of the model law, right? Article 26 of the UNCITRAL rules, if I'm not wrong. So there's a way to actually track how people around the world in international arbitration are using that standard, which is why I think it's actually easier, and it would make it easier for the arbitrator to apply it. I would never tell an arbitrator you cannot apply any other standard other than Article 17A. I would say you should apply Article 17A because it's what everyone is doing, most people are doing in the field, and it's substantially easier. And look at all the case law that now you have to follow to apply it in one way or the other. And I think arbitrators would feel comfortable applying Article 17A, but they wouldn't feel comfortable if you tell them you cannot apply anything else. That's over pushing it,
Can I just
unless
jump-
you're in a model law jurisdiction, of
A
course.
brief comment on the irreparable harm, including it in the
Yeah.
contract. The one thing I was going to say is that you will have federal courts that'll go both ways. Some federal courts will find that it is evidence that there's some amount of irreparable harm, but many federal courts, there's a big, very robust body of law that will say the fact that you've called it irreparable harm does not make it irreparable harm. So I think that that's a good point for an arbitration agreement and an arbitration standard. But in terms of your taking it to a federal judge, you'll have them often come out that it's interesting.
Yeah, I was going to
And I
say
also
that.
want to apologize because I'm actually going to have to leave in just a minute. And I so enjoyed this, and I want to thank you all for having invited me.
Yep, and then, so we've got.
Sorry, my question was to Judge Forrest, but as she's leaving, then, hi, Fred Sigaranja, a barrister from London. My question was, if public interest was what tipped the balance for you on this, then you said that if they came back in 3 days with a contract signed, then that might be what made the decision. But with the price, because presumably they want to get out of the contract because they're going to get a more favorable deal, and that means that the public will be paying a higher price for the PPE ultimately. So in your public interest consideration, would the price of the new contract and the ultimate price the public would pay, would that fall into it?
No. And the reason is because courts don't like to be price monitors and price setters in an otherwise competitive commercial environment. And so I think that we all know what happened with PPE and the price situation that evolved. But at that point in time, all we knew was there was scarcity. And so what I would be much more concerned about is smoothness of the distribution arrangement. And I would, there'd be a different case if they raised price too high. It would be a consumer protection case with the FTC.
Thank you.
Thank you. And I think we do need to end. So we have two more hands I've seen. So let's do that, and then we'll unfortunately have to close. So we've got one right here.
Yes. Hi, I'm Jonathan Cohen, an arbitrator based in New York City. There was reference to New York law, but it's unclear to me what would persuade the judge or the arbitrator to rely on New York law. And to the extent New York law is relied on, are we talking about state or federal case law? There was no reference to any specific case law, and since the state and federal case law is typically, again, much more demanding in terms of entitling one to an injunction, how could you give some more insight as to when and how you might rely on specific New York federal or state case law in a case like this?
I'm not going to pretend to be Judge Forrest. But I think you had some references to cases in the first argument to the standard. I mean, it's so difficult when you have this kind of a format, but my understanding is you would be arguing New York law to a New York judge. And if you're in federal court, you'd find federal cases. Yes, Benno.
I think what Judge Forrest would say is that in her courtroom, you'd be arguing the federal rules of civil procedure
Right.
as interpreted by the Second Circuit.
Yeah.
And if someone cited, I think if someone said the CPLR to her,
It would not go
she
well.
would say that's not what Congress has authorized me to apply.
Yeah.
Go across the street. Yeah, and New York law, you could argue for New York state procedural law, it's fairly similar to, the federal standard, but there are differences. Clearly, there are differences between the two.
And there was a point in time where it was unclear under state law whether you had to prove irreparable harm, because the statute said, it just said in relief in aid of arbitration. And so if it aided the arbitration and preserved the status quo, there were some courts saying you don't need to have irreparable harm. So it's kind of it has evolved, and I'm not sure where we are in state court exactly at the moment, but there can be a difference if you're in state and federal court. So, but was your question, how does the arbitrator decide?
When would an arbitrator be persuaded by New York federal or state case law? In the example where counsel was saying, look, I think New York law should be looked at instead of the easier UNCITRAL 17A standard.
No, these are procedural issues. I mean, I think this is one of these distinctions between international arbitration and domestic arbitration. I think if you were at a domestic case, you may be better placed to answer, what an arbitrator would look at. In an international case, I think because so much has been written about this, I think people were aware that there are no standards in New York arbitration law, federal arbitration law that guide us, and there's a lot of discretion in the tribunal. And we look at the kind of sources that able counsel was directing us all towards. So I would come out, sort of closer to Mr. Sanchez's view, where I'd be looking at an international standard. Interestingly, I think you can make, and now here I'm looking at Joe, because we've been talking about this separately. You can make an argument there's no domestic standard either. There's no reason for a domestic arbitrator to look at New York law either, because New York law is for the courts. It's the arbitrators should, do what they think best, apply the standard they think most applicable in our circumstances.
Yeah, there's certainly plenty of arguments that there is no specific standard unless you're applying the procedural rules of the seat. And there is an argument for applying those procedural rules with respect to the injunctive relief at the seat of the arbitration. And you could argue between New York State or federal court precedent because they both are at the seat of New York. But pure New York law would be separate from the federal standard under the CPLR.
Yeah.
Yep.
Okay, so we have our last question over here. And then Jose, could you hand your microphone? Thank you.
Does it work? Okay. Thanks so much. I'm Ogeday, an NYIAC student. So what I wanted to ask was, it's actually a what if question about the standards. So what if the parties were to appear before the court first, and if the court was to reject the preliminary order or like the TRO, how will this affect the emergency arbitrators pick of standards if there was a slight upcoming change in the facts, and if parties were later on to appear before the emergency arbitrator, how will that affect the standards that the emergency arbitrator will choose? Thanks so much.
Well, I think it's very important that you said if there's a slight change in the facts, because there's a real res judicata issue there, which now I don't have to talk about. Yeah, it's a good question. I would not be obliged to apply a standard applied by a court in a circumstance, but I would have to think hard about the res judicata issue. But others may have other views. I mean, that's an interesting question.
Thanks. That would certainly make it harder for my client, because now I'm trying to basically convince him that the court got it wrong. And I'm gonna talk about the quote slight change of fact as much as I can. But I mean, that's we don't know exactly what changed, but she's going to be trying to go back to this has already been decided. That is not a material change. This is all the same, and he's not going to feel bound by that decision. I mean, we can talk about the res judicata, setting res judicata aside, but it's instinctively he's going to think, well, I mean, why am I getting a second bite at the apple, right? Even if there is no res judicata, I would feel instinctively as claimant's lawyer that my job just got harder. But if there is a change of facts, and I'm just going to pivot to something that was said earlier, and would be to your question too. If there's a change of facts, what I would do if I were Greta is, let's say that now there is a contract signed 3 days later with that third party. Greta can, of course, go to Grant and then say, well, you can also change your order. And all these institutions allow the emergency arbitrator to change his order before an arbitral tribunal is constituted. So what I would do is I would go get that contract signed, come back and say, boom, that argument that there is no contract and no harm to my client is all gone. And now you can revisit that. And that's actually not a slight change. That's a material change completely within their control. So that's not the end of the road for Greta either. I'm just, it's a small victory, but it's not. A change of fact can change everything like overnight.
And I actually have a pending matter right now where the emergency relief was denied, and then there's a change of circumstance, and that exact consideration is happening. as to whether or not there should be a revisit, a reapplication to the emergency arbitrator to change, to adjust based upon a new event that is coming up that will cause irreparable harm. And that's a consideration that often parties grapple with, is whether or not you go back to the emergency arbitrator, you try to get an expeditious appointment of the entire panel so that you can get before them to change perhaps the decision maker. But change circumstances do come up in that interim period and can give rise to a different result. We appreciate everyone, all the participation of all the panelists.
I want to particularly thank Martin for this problem. I mean, these problems are a lot of work, and this was an exceptionally good problem. So congratulations.